came in a matter also by his distant friend and father, Refusal, and McDonagh and another.
Good morning, my lords.
Yes, Mr. Rose.
Yes, I appear in this matter on behalf of the appellant claimant. My learned friend, Mr. Horlock, appears for the respondent, second defendant. The first defendant doesn't appear and is not represented, and he took no part in the proceedings below.
Yes.
By way of introduction, the claimant's litigation friend is not present in court this morning. Unfortunately, he's been afflicted by COVID, and although he's out of quarantine, it was felt best that he observed the proceedings by the live stream, and that's why.
Yes. Well, I'm glad we got the live stream so that he can see what's happening.
So, my lord, this is an appeal from a decision of His Honour Judge Gargan, sitting as a Deputy Judge of the High Court in London at the end of last year. Permission to appeal was granted on paper by Lord Justice Bean. I propose to make three submissions in this case, and I can just outline those 3 points at the outset. The first submission is that the judge's reasoning that the claimant ought to have appreciated the speed of the approaching car was flawed because he equated the claimant's perception of the car with that of a number of witnesses.
Oh, I'm sorry. That's just... So I wouldn't normally have brought my computer in, but...
You may need it.
Well, I don't know. We'll see.
Because he equated the claimant's perception of the car with that of a number of witnesses who saw and heard the car in very different circumstances. And we say that is an error in the judge's reasoning that was fundamental to his decision. My lords, the second submission is that the learned judge was wrong to conclude that the claimant was partly responsible for the damage sustained, having regard to blameworthy conduct and causative potency. And thirdly, if I'm wrong about points 1 and 2, then it is submitted the learned judge erred and was wrong to find, in the event of any responsibility for the damage on the part of the claimant, that it was just and equitable to make a deduction of 10% from the claimant's case. My lords, as I've indicated in the skeleton argument, a loss of 10% on liability in a case of this size is a very substantial deduction indeed. And I don't think it's in dispute that if this case was resolved on a lump sum basis, that might be as much as £1 million. It's probably a case that would be resolved by periodical payments, and therefore a 10% shortfall in periodical payment is also a serious impediment to providing the claimant with the care that he needs. So, although it may seem in the ordinary run of things that a 10% deduction is not much to argue about, as it happens in this case it is. My lords, before I develop those 3 points, I wanted to do 2 other things. I wanted to just show you the locus of the accident in a little more detail. And secondly, I wanted to summarize the findings of fact that were made by the learned judge, all of which we, of course, accept and don't seek to challenge. Could I invite you, please, to look at the core bundle at page 43 in paragraph 66.
So which page did you say?
It's page 43 and it's paragraph 66.
Yes, thank you.
In this part of his judgment, the judge is dealing with the point of where the car was when the claimant set off to cross the road. And he begins the paragraph by saying there was some dispute between counsel about the position of the focus when the claimant started to cross the road. He then sets out the dispute, and then about 6 or 7 lines up from the bottom of the paragraph, he continues, using a reference point on the plan. Using a reference point in the plan, which is more easily identified in the photographs, this places the focus just to the east of the small tree on the northern footway. This tree can be seen in photograph at 542 between the Volvo estate and the silver Vauxhall parked in front of it. The position of the tree can be seen more clearly in the photograph at 537, which gives the view that would have been available to the first defendant. And my lords, in a moment I'll just take you to those 2 photographs which are in the supplementary bundle. But at this point I'd like to show you the relevant part of the drive-through video that was taken by the reconstruction expert for the defendants, Mr. Saughton, because one can pause the video at the small tree identified by the judge, and one can see the view available to the driver, and one can also see where the crossing is in respect of that. I, of course, appreciate your lordships are able to visualise 42 metres in your mind.
Well, not necessarily, but we have, of course, perhaps I should make this clear, all watched all the material supplied to us on memory stick. I'm not saying don't show us again, but this won't be the first time we've seen it.
Well, I'm most grateful. It may be that with some familiarity, then I can just pick out the critical
please do.
From our perspective. So there is a screen here,
yes,
which I hope all 3 of your lordships are able to see.
I certainly. I think
I'm starting the Saughton video 1 minute into the video. Press play. So he's introducing. So he's now driving down Caxton Road, which of course is where the first defendant set off when he was fleeing the police, and he's going to turn left into Bulwer Street. And I'm going to ask Ms. Nicklin to pause the video at about 1 minute 37. Stop now. So, my lords, the video's been stopped, and although there is a car coming towards the cameraman, on your left-hand side you can see the parking bay, which has got a people carrier in it, and then on the right-hand side of the road you can see a Vauxhall motor car, and then you can see ahead of the Vauxhall motor car the small tree. And that is the tree the judge is referring to in paragraph 66 of his judgment, and his finding of fact was that the front of the Focus was, broadly speaking, at that point along Bulwer Street when the claimant set off across the road.
Just so that I'm not getting confused already, the small tree is the one to the right of the centre of the picture where the curve of the fascia from the car sort of comes up, is it?
It's on the right-hand side of the screen, my lord.
Can you indicate it with the cursor?
Yes,
that one?
There are 2 trees. There's one you see the whole of going right down into the pavement. There's one you only see half of. Which of the 2 is the one you're referring to?
On the screen I've got, Miss Nicklin's put the cursor by the tree I'm referring to. I'm not sure if that's on your screen.
No, we can see it.
Okay, that is the tree.
Yeah, okay.
And the rather fuller tree on the left-hand side, further away, beyond the oncoming car, is that the tree that is shown on the police plan to the east of the junction?
My lord, yes, that would be the case.
Thank you.
So if you can play it on and stop it at 1:37, please. So I've stopped at 1:37 because you can just see that, as it happens by chance, there is also a pedestrian crossing the road as this vehicle approaches. I don't know whether you can see the pedestrian if you just play it on fractionally. So in the middle of the road now, there is a pedestrian. That pedestrian is crossing from the east side of Aldine Street. So that is the T-junction with Bulwer Street. The claimant was crossing from the west side of the junction.
So fractionally further away.
Well, it's more than fractionally, my lord. It's about 12 metres further away.
Yes, I see. Sorry, yes.
And one can see that actually from the police plan. So it's about the claimant is a further 12 metres away from the car when he sets off. If you play it through and stop at 144, please. Just pause now. So your lordships can see there's a bollard there on the west side of the mouth of the junction.
But again, it'd be helpful if that was just indicated with the cursor. Yes, thank you.
As it happens, that bollard wasn't there, but that is positioned on what's referred to in the judgment as the built-out area of the curb. If one plays on to one...
And that is where he would have stepped off from?
That is where he stepped off from, my lord, yes. Play it on to 144, please. A bit further. So I've paused it at 144. Your lordships can see where the bollard is on the south side of Bulwer Street, and on the west side of its junction with Aldine Street, there is the built-out part of the pavement, and there are parking bays on either side of the pavement. The claimant crossed at that point. As one looks back down Bulwer Street, that small tree that we located earlier is some 42 metres away. So when he leaves the curb, the car is 42 metres away. Where I've paused the video at 1 minute 44, the claimant is crossing the road there. The distance between the edge of the built-out part of the pavement and the line of the northern parking bay, so you can just put the cursor on that, which is by the Volkswagen Golf, that is a distance of 4.6 metres, which was an agreed figure, and the judge found that to be the case. If the vehicle was centrally located, in other words, he wasn't driving right up against the parking line on the northern side of the road, then the distance that the claimant would have needed to travel to clear the path of the car is less than 4.6 metres. It would in fact be 3.6 metres. So that is the activity, effectively, the claimant was undertaking. The judge found that the probable walking speed of the claimant, as agreed by the reconstruction experts, was 1.69 metres per second. It follows, therefore, that what the claimant was doing in order to complete crossing the road safely would take 2.14 seconds. That is the scope of his activity.
2.14 to get, is that to get to the line of the parking bay, or is that to clear the oncoming car?
That is to clear the offside of the oncoming car.
On the assumption that he's only got to walk 3.6 metres because the car's centrally located.
3.6, my lord.
Yes.
So it's 4.6 from the built-out area to the...
That's what I said, 3.6.
I'm sorry, I didn't hear my lord. Yes, that's correct.
On the assumption he has to walk 3.6 metres, because that assumes the car is centrally located.
That's right.
Yeah.
Which,
Yeah,
given
it would be marginally different. You may pick me up on marginally again, depending whether the car was centrally located. It could be even less, or it could be slightly more.
It could be, but one's talking fractions of
No,
a second.
of course.
What we're really talking about is 2 seconds,
Yeah.
isn't it? From when he steps off to impact.
Okay.
Give or take a 10th, or 20th, or 50th of a second.
My lord.
So all of your submissions really have to be framed by reference to that the car was in view it was, as a matter of fact, never mind attribution, going at a speed which meant that it was 2 seconds away.
My lord, yes.
And your client was in the road, or assuming he moved off at that moment at 1.9, which is a little bit unreal. He was in the road for 2 seconds before he was hit.
And all the agreed evidence, I think, was it was 2.1, but 2 seconds is obviously
it's
the appropriate.
1.2. Yeah. And the 10th of a second is...
It's immeasurable.
Exactly. And it's spuriously accurate if one starts trying to pretend that it's exact.
Precisely. It's simply not capable of that degree of precision.
So it's 2 seconds, really.
My lord, yes.
Can I ask you, while we're looking at these numbers, do we know what speed Mr. Saughton drove at in the video we're looking at?
He's a pretty law-abiding chap, Mr. Saughton.
It seems quite a careful speed.
And I don't think you saw it because I started the video a minute in, but there is a caption earlier in the video that says speed limit 20 miles an hour. I think the reasonable inference is that Mr. Saughton was driving at 20 miles an hour until he's confronted.
Or less.
Or less.
Or less. Because I think the judge found you'd actually drive slightly slower if you were driving carefully.
Yes.
But the judge's finding, and it was based on 2 pieces of evidence. One was one of the police officers at the time said you'd probably drive less than 20 down this road. You haven't got it, but there was an analysis of CCTV evidence of the car going past a law college, as it happens, just past the accident scene. And that captured 2 vehicles that went through that CCTV before the defendant, and they were travelling at about 15 miles an hour. So that was the basis of the judge finding that a reasonable speed...
There were more cars parked, I think, and that tends to make... I think there were cars parked pretty thick on both sides, weren't there?
There were roadworks as well, down from the driver's point of view, down
But
the
in any
right-hand
event,
side.
nobody's challenging the judge's finding that the safe speed was below 20.
No.
I think my lord was just wanting to get into his mind the difference between...
Well, what I was really thinking about is it seems quite a long time on the video to get from a little tree to the crossing point, but that's because Mr. Saughton is not driving very fast.
No, and one would say he's driving in a way that is respectful of a residential road.
And indeed, he's got a car coming up the other way.
He's just stopped for the other car.
He does. Yeah. And of course, your lordship will understand that at the forefront of my submission in this case is that the learned judge found that this defendant drove at 45 miles an hour down this road, which is 3 times the reasonable speed.
I don't think anybody disputes that the learned judge found that the first defendant drove appallingly.
Well, no one disputes that, my lord, but we have some difficulty with, after all the findings of fact, which on any view are helpful to the claimant, that the outcome was as it was. My lord, the final point I make in terms of the dimensions of the locus are this. Looking at the screen at 1 minute 44, you can see the parking bays on the south and north side of Bulworth Street. The distance between the parking bays was between 3.65 and 3.8 metres, depending on whose measurements you took. My lords, I've really effectively...
Sorry, I've not understood what that 3.65 and 3.8 metre figure refers to.
Yes, so when one looks at the frozen screen, just to the right of the bollard, you can see there are the white lines of a parking bay.
On the left-hand side?
On the left-hand side.
Yes.
And then opposite, where the Volkswagen is located, are the lines of the northern side parking bay.
So it's a distance between the 2 white lines?
There's those 2 white lines.
Why is that material over and above what you've already told us?
Because it might be said that the width of the carriageway realistically was not from the built-out area of the curb, rather it is the gap between the 2 parking bays. because there are likely to be cars parked there, and indeed, when one looks at the police photograph, there were cars parked there. But it's a marginal difference, my lord, given the margins one's dealing with. But that was the agreed evidence. My lord, the judge also referred to still photographs. It may be you feel that you have a sufficient grasp of the locus, but there are two that might assist you. They're in the three, in fact. They're in the supplementary bundle. And first of all, at page 154, which is behind tab 16, so this is
very similar to what we've just seen.
It's very similar, but obviously the camera is slightly further back, but it does show the tree that the judge is referring to. It's page 154, my lord.
Yeah, I've just noticed that I'm sure it's personal, but I don't have pages 152 to 156. So if I can just look briefly at my lord's.
My lord, I do apologise
Yeah,
for that.
that's fine. Thank you.
My lord, when your lordships break at a convenient moment, I'll ensure that one is taken from Melania Junior's bundle and inserted in your bundle, and that way you'll have a complete set. My lord, the other photograph is at 159. That is the view from the edge of the built-out part of the curve, looking in the direction from which the defendant came, and you can see centrally, but to the left partially, the Volvo that is referred to by the judge, and then ahead of that the Vauxhall, and then in between the two the small tree that he refers to.
So is that the view your client would have had
It is,
when
my lord.
crossing? So if we can see how far 42 metres looks on the ground.
Yeah, so he at this point, the judge found, my lord, that the photograph at page 158, which is turned back one page, that is further back on the pavement. And the judge found that the claimant would not have had a view from that point because there was a car parked that would have obscured it. That's the Fiat 500, which is in the police plan. But the judge found the claimant's view would have been one that he had from the edge of the built-out area, and that's 159. And my lord, that is to be found in the judgment of paragraph 67.
And when you say the police plan, that's the one at tab 1 of the supplementary.
My lord, that's at tab 1, and if you look at that, you can see drawn onto the plan is the Fiat 500. It doesn't say it's a Fiat 500, but if you look to the right of the mouth of the junction of Aldine Street, you can see there's a car parked there, and with the advantage of having seen the photographs, which you haven't got, that's the Fiat 500 the judge has referred to. And in a response to an observation I think my Lord Justice Underhill made about the significance of the parked line, the parking area lines, I indicated to the court that there were vehicles parked at the time of the accident, and that is apparent on both sides of the road from the police plan. And I also indicated to your lordships earlier that there were roadworks taking place, and you can see that they are also referred to on the right-hand side of the plan on the north side of the road. My lords, that is the observations I make about the locus in quo. I want to just summarise the material findings of fact that were made and then develop my 3 points, please. My lords, the first finding of fact, as we've just explored, is that when the claimant set off from the curb, the car was 42 metres away. Secondly, the defendant was fleeing the police, the judge inferred not simply because he was involved in criminal activity, but because he was also under a suspended prison sentence, and therefore, if apprehended, that was likely to be activated. Thirdly, he was approaching at 45 miles per hour. Fourthly, when he hit the claimant, he did so at 40 miles an hour. As I just indicated to your lordship, CCTV captured two other vehicles driving ahead of the defendant 50 seconds before the claimant crossed. They travelled at less than 20 miles an hour. The judge found the reasonable speed to travel along the street was 15 miles an hour. The judge found the claimant crossed from the built-out section of the pavement on the western side of Aldine Street. The distance between the built-out area and the northern parking bays, as I've said, is 4.6 metres. The gap between the parking lines, as I've said, is 3.86 metres. The judge found that both claimant and defendant had a potential mutual view of each other of 75 to 77 metres. The judge found the claimant was familiar with this route and had walked it many times with his father. As the court has already observed, the judge found to travel from the curb to the point of impact would have taken about 2.1 seconds. To avoid the accident, the claimant would have needed to travel a further 30 centimetres. The judge found that would have taken him 0.18 of a second. Critically, in our submission, the judge found that if the claimant set off when the vehicle was 42 metres away and the car had been travelling at 15 miles an hour, the claimant would have reached the safety of the northern parking bays with 3.3 seconds to spare. In other words, he would have crossed the road with comfort and ease. Again, critically, the judge found the claimant did look to his right before setting off to cross the road. This is not one of those cases where a young person runs into the road without looking. The judge found as a fact he looked to his right before setting off. Finally, the judge found that the claimant's ability to hear traffic was impaired, first by virtue of a perforated eardrum, and second, because he was wearing headphones. My lords, can I come then to my first submission? And this involves considering paragraph 89 of the learned judge's judgment, which is to be found in the core bundle at page 48. And the complaint we make is that the learned judge has equated the view that the claimant had of this vehicle with the view that a number of bystanders who gave vivid descriptions of the vehicle. And that was a fundamental premise of his reasoning. I made this submission when I applied for permission to appeal to the judge in person, rather than going straight to the Court of Appeal, and the learned judge rejected that and said it did not form part of his reasoning, and that is set out clearly in his reasons for refusal at page 51 of the appeal bundle. Our position is that whatever its role, it is not a redundant beginning of the paragraph, and it begins as follows. The witnesses who saw the focus, and my lords, there are three groups of witnesses who saw the focus. There are the police officers, there are the three young people who were on the northern pavement of Bulworth Street, and there is a Mr. Jones. The witnesses who saw the focus comment upon how badly and how fast it was being driven. In my judgment, that should have been apparent to a reasonable adult who had made an appropriate assessment of the dangers he faced in crossing the road. The problem in my submission with this beginning of the judge's analysis is that in the second sentence, he says, in my judgment, that should have been apparent. That refers back to two things. First, that the vehicle was driven badly, and secondly, it was driven fast.
That would have been apparent to anybody keeping a careful watch out, looking down and seeing the car.
Well, my lord, it would have been...
Any adult, which is where we are at the moment.
Indeed.
And he makes that finding, and then he deliberately turns and says, I have to consider whether a reasonable 13-year-old. So, I mean, you can't submit that it wasn't being driven badly and fast.
Well, it wasn't necessarily being driven badly at that point. It was being driven fast. The point is that the witnesses who describe it as being driven badly are viewing very different parts of the narrative, and also viewing it in some instances for a much longer period. We know that the claimant has it there for a matter of 2 seconds or so when he sets off to cross the road. We'll see that Mr. Jones, who's one of the witnesses the judge relies on, has it in his view for 200 metres. And the ability to assess how a car is being driven over 200 metres is very different from the view you have if you're expecting. And what you expect to see is conditioned by what you're used to experiencing on that road.
I'm sorry to trouble you, but you may cavil at the word badly, but the fact that this car was approaching at high speed was clear to be seen by anybody who kept a careful lookout and looked down the road.
Well, my lord, whether it's clear is a moot point, because as the judge records, when he records the passages from the Highway Code at the beginning of the judgment, it's observed that it's often difficult to observe the speed of a car that's driving towards you as opposed to one that is driving across you. So with respect, my lord, I don't accept that it is obvious that the car is being driven.
No, well, that is no doubt so, but the judge made a finding of fact. I'm bound to say I find hard to challenge that a reasonable 13-year-old looking at it would see this car was coming much faster than he was used to.
But the jumping off point for that finding of fact, my lord, is the fact that other people had observed.
Well, is it really? Is it really? I take the point that it's there in the first sentence, but I don't think you can read the judgment as all dependent on that first sentence.
There's the second sentence, my lord, as well. In my judgment, and that refers back to badly and fast.
Well, same point.
Should have been apparent to a reasonable adult, and then, as my Lord Justice Stuart-Smith observed, the judge then moves on to consider the position of a reasonable 13-year-old. But the jumping off point for all of this is the judge's reliance upon a number of witnesses who have viewed a very different scenario to that which the claimant viewed and that which was available to the claimant to view. My lords, I don't know whether in your pre-reading you had the opportunity to look at the statements made by the two police officers and the statement made, for example, by Mr. Howarth and Mr. Jones.
Well, speaking for myself, I didn't, but I'm not sure it's necessary for the point you're making. I quite understand the point you're making. It's a question of reading the judge's judgment, reading paragraph 89, and seeing what he's really saying and what his process of reasoning is. I take your point, which is based on the first sentence, but also the second.
But I wonder, I mean, it is a fact that the car was being driven fast. That's not disputed.
No,
It's part of your case that it was being driven appallingly fast. So when the judge says, well, other witnesses comment how fast, we can leave aside badly because it's really the speed which is the critical point. Other witnesses comment how fast it was being driven. It doesn't follow from that, but his process of reasoning is, well, Mr. X saw that it was being driven fast, therefore your client should have seen that it was being driven fast. He doesn't say that. And isn't he just introducing it by saying, what I have to decide is whether a reasonable 13-year-old should have spotted the car was coming towards him at high speed. And he's just introducing that question by saying, well, it was being driven fast and all the witnesses said so. I'm not sure that you can get from this sentence that it is part of a judge's reasoning that because A and B and C saw that it was fast, therefore the claimant should have done.
Well, my lord, it's a careful judgment. It's a reserved judgment. And I say with respect, these are not introductory remarks. It didn't require any introduction because he's rehearsed paragraphs 46 to 52 in his judgment, the evidence of the witnesses. What these witnesses saw was, first of all, the police witnesses. They approached the car in Caxton Street. The door was open. They wanted to remove the keys to the car, and the defendant drove off with the door open and two police officers around the car, who obviously felt threatened for their personal safety. They watched it go down Caxton Street, swerve around the corner.
Well, we've seen
control.
I understand the temptation, Mr. Rose, to rub it in just how bad the driving was, and I'm speaking for myself, and I know for my lord, we're very alive to that. We have watched the video, so I don't think you need to.
But my lord, this is what, when the judge says, witnesses who saw and focused upon how badly, okay, the badly point is the point I'm referring to, not the fast point, the badly point. This is what he's referring to. And then the police officers have got the vehicle under observation because they are trying to take down the vehicle registration mark. They're therefore studying it and watching it. They then watch it go down Bulworth.
We have your point. They were there. The circumstances which they were observing were wholly different. Here you've got a child, as it were, minding his own business, looking up the road at the moment when a car is approaching at 45 miles an hour. There's no reason to believe it was being driven badly in the same way as it was being driven badly in some of the videos and as you've described. It was simply, it was coming very fast. The point is, should he have appreciated it was coming very fast?
When one reads on into the third sentence, or the end of the second sentence, because I stopped halfway through, in my judgment that, and I say that that refers not just to speed, because the badly is an add-on to the speed. That should have been apparent to a reasonable adult who'd made a reasonable assessment of the dangers faced in crossing the road. I then have to consider whether a reasonable 13-year-old with the claimant's experience should have been made to should be expected to have made the same judgment. So the judgment that is being reviewed is premised upon a false factual scenario. The claimant
if you read, I'm sorry, Mr. Reid,
Yeah.
if you read on the rest of the paragraph where the judge actually makes the relevant finding, it's all based on speed.
My lord, it is. But what
So-
puts the observer on notice about the speed is not simply the fact of the speed itself. It is the way the car is being driven. The other people see it in a very different
But
context.
the judge asks the right question, which is whether a reasonable 13-year-old should have been alert to the fact that this car was coming at high speed.
But his thinking as to why a reasonable 13-year-old would be aware is contaminated, you say,
Well,
because
I
he
agree.
starts
Well, that's
with
what
the
we have to decide on
He
a fair
starts
reading.
with the reasonable adult, my lord, and he finds the reasonable adult would come to that view because of how badly and the speed it's being driven at. But these individuals all see the car in very different circumstances. You just observed that when I referred to the police officers. The other cohort of witnesses are the three people on the pavement who hear the accident because it happens right behind them. They see the claimant fly through the air 2 meters above them. They then see a car that has hit the claimant not stop and drive off at speed down Bulwer Street. Their perception is wholly different to a pedestrian minding his own business, going about an everyday activity that involves a 2-second action in walking across the road that he is conditioned to expect vehicles travelling at 15 miles per hour at. He looks to his right, according to the judge, and he has misjudged the speed the car has come at. And my lord, we say that the judge has done more than simply introduce the paragraph. He has referred to a critical part of his reasoning, and we say it's skewed. It simply is not a fair comparison to compare the view the claimant had over 2 seconds with Mr. Jones, who had 200 metres, the police officers who were nearly run over themselves, and the 3 on the pavement who see a body fly over their heads and then a car drive off down the road without stopping. And so, my lord, we say that that is an error in the approach that the learned judge has taken.
Can I ask you, should we take into account what the learned judge himself said when you made this point to him at the PTA application? Can we use that to inform what we think his reasoning was?
I thought you might ask me that. Well, my lord, I think the answer I would take to it would make is it was either a subconscious or consideration, but it has worked its way into his reasoning. And I suppose the other point, of course, which is not made by the judge at this point in his judgment, is assessing speed is a multi-sensory activity. It involves the sense of hearing as well as sight. And the judge, of course, refers here to a reasonable 13-year-old. It doesn't at this juncture, make any allowance for the fact that he has already found as a fact that the claimant's ability to hear traffic was impaired by virtue of his wearing earphones and having a minor ear injury. My lords, I think I've probably done that point. So,
Yep.
can I take you to my second submission? My lords, the starting point probably is just, I know you're familiar with it, but it's appropriate, I think, to look at it, which is the statutory provision which governs this appeal, which is set out by the learned judge at paragraph 8 and page 33 of his judgment, page 33 of the core bundle, rather. The learned judge says the starting point is section 1.1 of the Law Reform Contributory Negligence Act 1945, which provides where any person suffers damage as a result partly of his own fault and partly of the fault of any other persons or persons, a claim in respect of that damage shall not be defeated by reason of the fault of the person suffering the damage, but the damages recoverable in respect thereof shall be reduced to such extent as the court thinks just and equitable, having regard to the claimant's share in the responsibility for the damage. In terms of the words responsibility for the damage, the authorities that begin with Lord Denning when he was Master of the Rolls have divided that up into 2 components, blameworthy conduct and causative potency. And if one turns to the next paragraph of the judgment, the learned judge sets out the very well-known passage from Lord Denning in Davies and Swan Motor Company. He says this: whether and if so, to what extent a finding of contributory negligence should be made involves a balance of blameworthiness and causative potency. Whilst causation is the decisive factor in determining whether there should be a reduced amount payable to the plaintiff, nevertheless, the amount of the reduction does not depend solely on the degree of causation. the amount of the reduction is such amount as may be found by the court to be just and equitable, having regard to the claimant's share and responsibility for the damage. This involves the consideration not only of the causative potency of a particular factor, but also its blameworthiness. My lords,
and it's, I think you haven't actually spelt this out, but it's implicit in your submission on this ground that it may be just and equitable to make no deduction.
my lords, there is a substantial overlap between my second submission and my third submission. My second submission is based on the premise that there was no blameworthy conduct. If I am wrong and there was blameworthy conduct, then my third submission is it was not appropriate and it was not just and equitable to make any deduction.
But blameworthiness in this context means culpability in tort, doesn't it? It's not moral blameworthiness.
No, it's culpability. I'm not sure that it requires a breach of duty vis-à-vis the claimant to the defendant.
No, it means fault on the part of the claimant means
Correct.
not taking reasonable care for yourself.
Correct.
Which, I mean, we're only in that situation, we're only in the Section 1 situation anyway if there has found to be such fault.
We're only in that situation if there's found to be fault.
So it really perhaps ought to read, but also of the degree of its blameworthiness, because there will be blameworthiness by definition, because there will have been fault.
Yes, and that's where the just and equitable provision comes in, because if in the overall scheme of the narrative of events, the blameworthiness on the part of the claimant is so eclipsed by the fault on the part of the defendant, then it won't be just and equitable to make any deduction.
But the context for the 45 Act is that before the Act, any contrib was a complete defence.
Complete failure. Yeah.
Complete defence.
Yeah.
And it's, as Lord Denning would have known because he was there at the time of the change.
Yeah.
And so it's interesting that Davis and Swan starts by saying that causation is the decisive factor, but there can be a reduction.
Yeah.
So there is a sense of balance in the statements of principle we've got. So it's not the act ameliorated the effect of the previous law of tort, the common law, but did not go so far as to remove the impact of contributory negligence, causative contributory negligence.
No, and there was an overarching control device, which is the just and equitable provision, and judges historically have approached the analysis under the 1945 Act by asking whether there was blameworthy conduct, and in road traffic cases the causative potency argument is always a strong one in favour of the claimant for the Eagles and Chambers point.
Which the judge adverts to later in the judgment.
Yeah, and then thirdly, there are a couple of decisions in the authorities bundle in front of you. The court has found blameworthy conduct, but nonetheless, and causative potency, but nonetheless concluded it's not just and equitable to make a deduction. And as I say, the distinction between my second submission and my third submission is my second submission is that there was simply not blameworthy conduct in the overall scheme, and the third submission is, well, if I'm wrong about
Would that be right if that was fault? You're making a distinction between fault and blameworthy conduct.
Lord, I don't see them as separate concepts. The reality is...
Well, sorry, maybe I'm misunderstanding you. Your second submission is that there was no blameworthy conduct.
Correct.
As I've understood it. But if there's no blameworthy conduct, then there's no fault.
The Act doesn't bite. It's not contributory negligent.
Yes.
Yes, but I hadn't understood
I'm having the same difficulties as my lord. I haven't quite understood what your ground 2 is. I understand ground 1, which we've had your submissions on. But if you lose on ground one, and the judge was entitled to find that your client should have appreciated the car was coming towards him at more than usual speed.
But that's a momentary misjudgment that is
Yes,
not properly characterised as fault.
So you're saying that even if he should have seen that it was coming towards him quickly, stepping off the curb was not failing to take reasonable care for his own safety?
My Lord, in almost every road traffic accident, unless a claimant is on the pavement or possibly on a zebra crossing or crossing with a green man, by definition there has been some misjudgment by the pedestrian for the accident to occur. But not in every case is a claimant found to be contributory negligent. There are misjudgments that are blameworthy, and there are misjudgments which are not blameworthy within the meaning of the 1945 Act. And my Lords,
the real question is whether there are misjudgments which amount to contributory negligence, i.e. there's got to be a finding of negligence, not breach of a duty to another person, but negligent conduct, a failure to take reasonable care.
Yes.
But your submission that it's a momentary lapse and therefore not blameworthy is impossible, because that would apply to every case where a pedestrian just walks out in front of a car.
Well, my Lord, it doesn't, because in those cases, often what happens is the pedestrian doesn't look, the pedestrian runs.
Momentary lapse.
Pardon?
Momentary lapse.
Well, it's a very different quality in this case, where the judge has found that the claimant has looked to his right, that the time frames involved are very minor, and the claimant is unable to hear the approach of the car. But, my Lord, the extent of the misjudgment in this case by the claimant is 30 centimetres.
Well, I think
Could you not get to, I'm just trying to understand how this works, could you not get to the result you want to get to, i.e. no deduction, that's ultimately what you want to get to, by saying that there was fault, but, and if you like, therefore also blameworthy conduct, but the extent of the blame was so small, momentary misjudgment, that it's not just inequitable to make any deduction for it.
My Lord, that's my third point.
Oh, that is your third point, is it? Yes, I see.
But logically, my starting point.
I understood your third point rather differently.
There was a skewed approach in analysis, which was my point one. My second point is that what the claimant did in this case simply was not blameworthy. It is momentary inadvertence, which is not worthy of the label of fault. If I am wrong about that, then I say, fine, there is fault to be attached, but it is so de minimis in the overall narrative of what happened here, it is not just inequitable to make a deduction, and that is the separation I make between points 2 and point 3.
Okay, well,
that's why I said at the beginning there is a factual overlap between the 2 points.
I understand that. And you accept, I think, when we're talking about fault of the claimant as opposed to fault of the defendant, what the judge needs to be satisfied of to trigger the act at all is the claimant has failed to take reasonable care for his own safety. And so it's that which the judge has to find, and it's that which finding, if he makes it, which is what you have to attack. Is that not right?
The question is whether it is correct to characterise what he found as happening in this case for submission to purposes as being fault or blameworthy. Is it right to characterise what happened in that way?
Isn't the correct way of formulating it? It's not quite so helpful from your point of view.
That's probably why I haven't formulated it.
Isn't the correct way of it is the judge has found that the claimant failed to exercise reasonable care for his own safety.
Well, I'm not sure he has found that, my Lord.
Well, that's what a finding of trib means.
Well, my Lord, he may have reached that conclusion, but he didn't make, in paragraph 89, all he has found is that a reasonable 13-year-old ought to have appreciated that the car was travelling at a high speed.
Yes, but he
No,
goes
no,
on to find that for that reason, either he should not have left the pavement at all, or if he had, he should have kept it constantly under observation so as to be able to accelerate
Yeah.
enough to get out of its path.
Well,
So it's that is the failure to take reasonable care for his own safety.
But the second point is parasitic on the first, because it's only
Well,
if he appreciates that the car
Yeah,
is
the
going
two go together, but he is found against you on both.
Yes, but it's really one point, because
Well,
the
all right,
second
but-
point is
okay,
triggered
well-
by appreciating the car. You should have appreciated
Yes,
the car was going too fast.
I dare say, but the fact is that however one analyses at 1 point or two, he has found that point against you.
And my quibble is that it's not correct, in the light of what was happening, to characterise that under the Act as responsibility for the damage. Those are the statutory words, and they've been interpreted in Davies and Swan as meaning blameworthy conduct and causative potency.
Well, I must say, I hadn't thought we were going to have to get quite so deep into the weeds on exactly how Section 1.1 works, but it isn't that difficult, is it? Is there a distinction between fault and the concept of blameworthiness, which is not actually in the section, but is said to be part of the concept of responsibility?
My Lord, there are degrees of fault,
Of course.
and you have to cross a certain threshold for it to be blameworthy. As I say, in virtually every
Well,
pedestrian
is that
accident.
really right? I'd have thought that fault and blameworthiness are the same thing.
Well, my Lords, whether they are or they aren't, there are shades of fault and there are shades of blameworthiness.
All
And
that
we say-
feeds very well into your third submission, but it's
No, my Lord, it doesn't, because you have to, in my submission, cross a certain threshold before it is properly to be characterised as blameworthy
yes, but the
conduct.
threshold is failing to take reasonable care for your own safety.
But I'm not
And
sure
that
the
was
judge
found
has
against
found
you.
that.
Oh well.
But what the judge has found in the penultimate sentence of 89 is that a reasonable 13-year-old would have considered that the focus represented a source of potential danger and would have waited for the focus to pass. And that's a finding that what a reasonable 13-year-old would have done. The claimant hypothesised did not wait for the car to pass. Is that not a finding that in failing to do what a reasonable 13-year-old should have done, he was at fault for the purposes of the Act?
The question is, though, whether it is of a sufficient gravity, the fault, to amount to blameworthy conduct as understood in the authorities and understood under the Act. Whether the mere fact, as I say, in my submission, the vast majority of pedestrian road traffic accidents will involve some misjudgment on the part of the pedestrian. The question is whether that is culpable misjudgment or whether it is simply...
And it's culpable if it is the consequence of a failure to exercise reasonable care for your own safety. It is not culpable if it is attributable to some other reason. I mean, you're using another word, culpability, blameworthiness, responsibility. These are... the working of the Act is well known. If you have contributory negligence, i.e. a failure to exercise reasonable care for your safety, and if a person suffers damage as a result, partly as a result of his own fault, and partly as a result of fault on the other person, i.e. negligence on part of D, contributory negligence on part of C, then the claim shall be reduced. And then you get into to the extent that is thought just and equitable, having regard to the claimant's share in the responsibility, which is said to be primarily causation. And that's been the position for about 70 years, I think.
And equally, my Lord, equally there are any number of authorities where claimants in both industrial accidents and in road traffic accidents, their conduct has been described as momentary inadvertence. they have obviously been at fault to some extent. It's described as momentary inadvertence, and they are not found to be contributory negligent.
Well, is that right? Is it not that they are, it is not thought to be just and equitable to make a deduction? If necessary, and none of these cases are binding on us, but I would have thought that, at any rate, none of the first instance cases are binding on us. I'd have thought the better analysis is that in those momentary misjudgment cases, they are found to have been, if you like, contributory negligent, but it is not thought to have been just and equitable to make a deduction because their fault is so small.
Well, my Lord,
To me, that's the more attractive approach. But
I don't appear tone deaf
no,
to the court.
well, my lords may not agree. You're perfectly entitled to say no. That's the better analysis is your submission to analysis. But you were saying there are lots and lots of momentary misjudgment cases. Are there any in this court, or indeed in the House of Lords or the Supreme Court, which analyse it your way rather than my way?
Off the top of my head, my Lord, I can't answer that question.
I've had a quick look at the ones in the bundle, and the main ones people refer to are first instance ones.
Yeah.
My understanding, but I didn't analyse them in great detail, is they're just as consistent with your submission 3 as with your submission 2. They're not always very carefully reasoned.
I mean, if one looks, for example, you mentioned the authorities. If one, for example, I can't remember precisely how His Honour Judge Friedman put it in the case of Craven and Davies, but that was a case where the judge's analysis is effectively the analysis that I am adopting for submission 2. My Lords, it's at the 4th in the bundle of authorities. This is a case where the speed of the vehicle was higher. The speed limit was 40 miles an hour and the vehicle was travelling at 80 miles an hour. But of course, in proportionate terms, we've got a car that's going 3 times the...
Well, the facts don't matter. The question is simply how he analysed it. In paragraph 11, he says, even if he was guilty of a degree of inadvertence, in my opinion, it did not amount to negligence. And that could be translated into it did not amount into a failure to take reasonable care for his own safety, whereas the judge here made the contrary finding.
Yeah, but that is my submission. It's difficult to see, first of all, in terms of whether this point I'm making is a pure, just and equitable point, or whether it's a point that's legitimately made under...
Well, you're confusing me, Mr. Rose. I now do not understand. Are you trying to challenge the judge's finding that a reasonable 13-year-old would have appreciated the danger if they had looked as they should have done?
No.
In that case, you've got a finding of contrib. Boom. Now you can get onto your third point.
Well, my Lord, it's difficult to see why the judge is not entitled to make that finding, but then characterise it as a result of inadvertence as opposed to fault. Which is the finding that the judge made in the case of Craven and Davies.
Just looking at Ellis and Kelly, this is Justice Yip. It might be something in for both sides, but paragraph 62, she says, I find that this was a case of momentary misjudgment on the claimant's part, balanced against reckless conduct on the part of the defendant, whose driving was outside his expectation. In my judgment, it would not be just and equitable to make a finding of contributory negligence in these circumstances, and I decline to do so. That, I think, is more a submission 3 analysis.
Correct.
It's rather compressed.
Yeah. Well, my Lords, can I then go on to submission 3? So this is on the assumption that I'm wrong on 1 and I'm wrong on 2. Can I begin by asking you to look at one of the other authorities that is in the bundle? It's a first instance decision of His Honour Judge Bird, who is the designated civil judge in Manchester. It's the case of Al-Abadi and Akram, and it's the fifth bundle in the authorities. And can I ask your lordships, please, in the interests of economy of time, to read to yourself paragraphs 1 and then 8 to 11.
Sorry, paragraph 1 and...
Then paragraph 8 through to 11.
Yes.
Just so you've got some
No, thank
sense
you.
of the facts.
Yes.
And my lord, the reasoning of the learned judge begins at paragraph, well, the relevant part for my purposes begins at paragraph 38.
Before you get there, the judge cites at paragraph 21 from the decision of the House of Lords, in which Viscount Simon says that all that is necessary to establish the defence of contributory negligence is to prove to a satisfaction of a jury that the injured party did not in his own interest take reasonable care of himself and contributed by that want of care to his own injury. Is that is the test that has to be applied as to whether someone is at fault?
Did they take reasonable care?
Yes.
My lord, yes.
For of himself.
Yes.
And I'm afraid I'm still not entirely sure whether your submission on ground 2 was that on these factual findings, the judge should not have found that the claimant failed to take reasonable care of himself, or whether that it is that the judge was entitled to find that he didn't take reasonable care of himself, but he shouldn't have attached any blame to it.
I would make both points, but in descending order.
Yes. I see.
So it is possible to find that somebody has not taken reasonable care, but that can also be as a result of mere inadvertence as opposed to blameworthy conduct.
Thank you.
My lord, if one turns to paragraph 38, your lordships have got a feel for the facts of the case. It was a younger claimant, a 9-year-old, and the learned judge says here, when on the crossing, Khadija's momentary lapse of concentration, which caused her to move ahead of the group, does not, in my judgment, amount to fault. And that, of course, is the position I took in my second submission, that what happened didn't amount to fault. But I'm dealing with a separate point now. My second point is, if I am wrong, the judge says at paragraph 39, so that's now the territory I am in, and Khadija in fact failed to take reasonable care of her own safety, I would have found her failures cause in part her loss. That's the causative potency point. I would then have needed to consider the question of apportionment by reference to the causative potency of her failure and moral blameworthiness. I'm not sure moral blameworthiness has anything to do with it. If one then moves on at paragraph 40, weighing up the facts of that case, the judge says, had my decision called for an apportionment, I would have reached the firm conclusion, bearing in mind Khadijah's age and all the circumstances of the case, that the reduction in damages would have been minimal and at the most 10%. I'd have regarded such a reduction as de minimis and would therefore, in any event, have made no reduction in Khadijah's damages. So that's obviously an obiter observation, but it's plainly one that I would pray and aid in this case. And my lords, the overall factual matrix of what has happened in this case is such that if there is a failure to take reasonable care in this case by the claimant, it is totally eclipsed by the conduct of the defendant. The claimant was undertaking an everyday activity which takes less than 3 seconds. He is on a road with which he is familiar. He will be conditioned as to the speed at which traffic normally drives down that road because he uses it frequently. He's looked to his right. By a misjudgment, he has not appreciated the speed of the car as it approached. He got it wrong by a fraction of a second, 0.18. If he had made it a further 30 centimetres, he would have been in safety. And my lords, 30 centimetres is my ruler. 1 foot, that is all he needed to make in order to clear the car. It could be said, well, that's a fine margin. You shouldn't allow such a fine margin. If you allow a meter's clearance, that takes half a second. So the degree of fault on the part of the claimant is de minimis. My lord, if the vehicle...
Mr. Rose, his fault isn't to be measured by reference to 30 centimetres or even a metre. His fault is to be measured by stepping into the path of a fast oncoming car when he didn't know that it was safe.
But that was a misjudgment, and it turns out his misjudgment...
Negligence is often a misjudgment.
But there are grades. In the overall narrative of fault, one has to equate the misjudgment of a 13-year-old boy who has made a minor misjudgment.
I understand that submission, but what I was picking you up on was your suggestion that the degree of fault is to be measured by reference to 30 centimetres, which is not a proposition that at the moment I feel able to accept.
Well, my lord, if he had moved slightly faster across the road than he has been deemed to have moved at, then he would have made it past the car, and it required only a very small fraction.
And if he looked to his right as he went across, no doubt he would have done.
Pardon?
And if he had looked to his right as he went across the road, no doubt he would have done.
That is premised upon appreciating that the car was travelling too fast in the first place.
We're only having this discussion on that premise. I mean, if he shouldn't have appreciated the car was travelling too fast, then you succeed on ground 1. We are, as I understand it, now on ground 3, in a position where the judge was entitled to find that he should have appreciated the car was coming fast and should not have stepped off the curb, or if he did, should have kept an eye on the car. And your submission, as I understand it, is despite those findings, which I think at this stage of your argument you accept amount of fault for the purposes of Section 1, his relative blameworthiness was so small compared to that of the defendant that no deduction should have been made at all. That's
it in a nutshell, my lord. And in support of that argument, I was making the point that when you break it down as to how the extent that he got his judgment wrong, it's actually in my submission de minimis, because he very nearly made it to safety. He was a fraction out with his misjudgment. The other way of looking at it is that if the defendant, as I said, had been driving at what the judge held to be a reasonable speed, then the claimant would have made it to safety with over 3 seconds to spare. In terms of the causative potency aspect of it, the evidence is all one way, because the defendant hit the claimant at 3 times the speed, just under 3 times the speed that the judge held to be a safe speed to drive down the road. He hit him at 40 miles an hour. And my lords, in the skeleton argument that I prepared for the permission hearing of this appeal, there was a citation from the Highway Code, which is germane to this point. And my lords, if you could turn please to page 16 of the core bundle. There is a footnote at the bottom of the page which reads that at the trial, the claimant drew the court's attention to paragraph 207 of the Highway Code. Particularly vulnerable pedestrians, these include children, who may not be able to judge your speed and could step out into the road. At 40 miles an hour, your vehicle will probably kill any pedestrian it hits. So in terms of the just and equitable argument, the causative potency of the defendant's negligence in driving at such a speed is responsible not simply for the fact of the accident, but also for the gravity of the damage that was sustained by the claimant. My lords, it was put to me that the claimant's fault lay not simply in misjudging the speed of the car, but in failing to observe it on its way across the road. First of all, one is dealing with 2 seconds here, but that particular argument has its genesis, again, in part of the Highway Code, which was quoted by the judge in his judgment. And it is, in my submission, important to see what, in fact, that part of the Highway Code actually says. My lord, it's in the core bundle at page 35. It's paragraph 14, and then the quotation is paragraph 7E. So it's by the second hole punch on page 35. When it is safe, go straight across the road and do not run. Keep looking and listening for traffic while you cross, in case there is any traffic you did not see, and in case other traffic appears suddenly. So that particular directive is aimed at traffic you may not have seen, or other traffic which appears suddenly, as opposed to somebody who is making a distance of under 4 meters. It takes 2 seconds. And indeed, in the case of Craven and Davies that I showed you, the decision of His Honour Judge Friedman, the same point was raised and was rejected by the judge in that case. My lords, to sum it up, the claimant is 13. He has impaired hearing. He has misjudged the speed of the approach of a car, undertaking an activity that takes 2 seconds. The defendant has driven furiously at 3 times the speed limit with a complete disregard. I shan't take you to the video footage because you've told me you've seen it, but you've seen the reckless manner in which he drove, endangering other road users, other pedestrians, cyclists. A total disregard for everybody else's safety, driven by one thing only, saving his skin. And when it's weighed in the balance, his conduct, the damage his conduct caused by the speed that he drove at, with the claimant's misjudgment, we say the scales are very heavily weighed in one way. And it is a massive imbalance. And in our submission, my lords, it is not just inequitable on those facts find any deduction in the claimant's damages. My lords, can I just take instructions whether there's any matter I haven't covered? My Lords, I'm sorry that it's taken an hour and a half of your time, but those are my submissions on behalf
If I may say so, you've made your submissions both clearly and cogently. Thank you very much. I think we'll just rise for a moment and just see where we are.
All right. Live streaming will remain on because they've only risen for a moment. So if I may ask you to remain in the courtroom, as they may be back very soon.
Didn't want him to give the judgment. Who is it going to be? Underhill? Really?
Court rise.
Yes, Mr. Horlock, there's no need to address us on ground one.
Thank you, my Lord. Can I start by dealing briefly with two matters of law? The first is the structure of the Act and what needs to be found by a judge in deciding whether a reduction is to be made. The second issue I'll deal with briefly is, with all due respect, the approach of an appellate court to a finding of apportionment in a case such as this, and what amounts to an error of law. I will not then deal with what I was going to say about the judge being entitled to make a finding of fault. In other words, that the claimant should have appreciated the speed at which the vehicle was travelling and that it was a potential source of danger. I will deal briefly with causation if your lordships want me to, but I will then move on to just and equitable, which is I suspect what this case is about more than anything. So looking at the structure of the Act, with all due respect, one can become confused if one ignores the terms of the Act and starts using phrases such as moral blameworthy or worthiness or culpability. In my submission, the starting point is, and the burden is on the defendant, has the defendant established fault? And that must mean failure to take care for one's own safety on the part of a pedestrian, as in this case.
Reasonable care.
Yeah, reasonable care. Now, if the defendant fails to establish that on balance, that's the end of it. The second issue is implicit in the final two lines, namely that it is for the defendant to establish a responsibility for the damage. In other words, a causative effect. I apologise, I'm falling into the trap that I said was to be best avoided, and using words which are not the words of the statute.
Well, you've got to do that because
Exactly.
Responsibility is an ambiguous term, but it's been explained by authoritative cases, and
Yes.
that's really what. So I think you're allowed certainly to use words like causation and
I'm
blameworthiness.
grateful for that allowance, Lord. And then, assuming that the defendant has crossed both of those hurdles, the judge then has to ask, is it just and equitable
in the light of the fault and the share of responsibility to make a reduction, and if so, what reduction? And in this case,
Hang on 1 second. Is it really even 3 stages? Isn't it just 2? Because you don't need to make a finding about responsibility. That will have been established when you've asked whether a person has suffered damage as a result partly of their own fault and partly of the fault of any other persons.
yes, your
So-
lordship is right. It's my mistake. That's where cause comes in. So the first thing is fault. The second thing is, has the damage been suffered partly as a result of own fault and partly the
Yes,
fault
one
of the
tends
other?
to ignore that bit because it's
Yes.
it's very rarely an issue.
Yeah.
Um,
So it's fault, it's cause, and it's then responsibility, just and equitable. Meaning that just and equitable and responsibility are the third element. And that is what the learned judge, Judge Bird, Manchester DCJ, did in Alabardi. He adopted that process, and that's why when one looks at what one means by a phrase such as momentary inadvertence, it was clear that he was saying that does not amount to fault, and therefore the argument doesn't get going.
On the facts of that case.
On the facts of that case, and in particular given the age of the girl.
and that's very common, obviously, in cases of negligence as a basis of liability rather
Yes.
than crime and contrib. A long time since I've done a lot of these, but it used to be said momentary inadvertence is not always a failure to take reasonable care. It depends. It may be.
Absolutely. And one thinks of a driver taking the eye off the road. If it's for a split second, then it may be exonerated in terms of fault giving rise to liability or contrib. But if it's more than momentary inadvertence, then we call it fault. But,
Well, all right. Okay.
or maybe we don't, but it's fact specific. And in this case, the starting point is I anticipate your lordships have favouring, given your invitation not to ask me not to address you on the first ground, is that the starting point here is that the judge's finding of fault is unassailable. And had I been asked to do so, I would have directed your lordships to the abundance of evidence, particularly the witness Jones, who makes it clear that that was a finding that was open to the learned judge. And it is important to remember what that finding was. It isn't just that he didn't appreciate the speed of the car. The judge expands on it in his judgment at paragraph 89. And this contains much of his reasoning in terms of what is just and equitable. So he specifically asks himself in the third sentence, I then have to consider whether a reasonable 13-year-old with the claimant's experience should be expected to have made that judgment. Correct, that's the correct approach. Many children can't judge how fast. However, at 13, I consider it likely the claimant would have experience of crossing roads on his own, even roads where traffic might be going at 40 miles an hour. Now, that is a finding that was open to him as a matter of judicial common sense, effectively, given the claimant's age and his experience at crossing roads. And he then says it would have been wholly wrong to expect him to have been able to estimate the precise speed, but in my judgment, a reasonable 13-year-old making a careful assessment would have realised the focus was being driven much faster than usual. So that's the fault, a failure to appreciate a speed of a vehicle being driven much too fast by a reasonable.
If one's being really analytical about it, the act, the causative act, which is the fault, is setting off, or in the alternative, setting off and then not
Not
keeping an
looking.
eye.
And
The
that's,
reason why it's a fault is because of the failure to appreciate the speed.
It's the starting point.
But the two acts are the two furthers.
Your Lordship is ahead of me. I was going to refer to the final sentence of paragraph 89, which is where the judge says that, starting from the proposition that a reasonable 13-year-old would have realised that the car was a potential source of danger. Then, in the final sentence, even if a reasonable 13-year-old had set off,
Well, you skipped over.
sorry, I missed the sentence before where he said,
Would have waited.
yes,
That's
so
the
don't
finding.
set off.
That's the finding of what a reasonable 13-year-old would have done in the circumstances. Would have waited.
So he doesn't go at all, but even if he does go,
Then you keep it.
he
under
then
lock.
keeps an eye out as he's crossing. And that's why the reference to the 30 centimetres is, with all due respect, misconceived. This is, he shouldn't have gone at all.
and he audits his view, doesn't he? By reference in paragraph 90, he picks up the submission that this is kind of infection,
Yeah,
and then he analyses that at 91 to 93, and then effectively repeats, in the light of that additional analysis, his conclusions at 94 to 96
yes.
in the way that you've just said.
Yeah.
So it's not just paragraph 89.
No, it's a careful, cogent, reasoned analysis of, well, what was the evidence as to what this car was doing on this particular road? How would an adult have appreciated that? Hence what Mr. Jones says. The judge then has to exercise his judgment as to what he understands a 13-year-old in these circumstances would do, because fortunately we don't have to have expert evidence on it as to the neuropsychological equipment that a young child of that age might have had. Judges are expected to apply their sense. And crucially, this is not a child of 8 or 9, where it might have been materially different. One sees that in the authority. So against that finding, the judge then has to look at cause as a result, and bearing in mind that his finding, which in my submission is unassailable, is the claimant would not have set off. Even if he would, he should have been watching. Then it's causative simply because the claimant steps into the road. And therefore, the judge can't be criticised for finding that as a result partly of his fault, because undoubtedly it does play a contributing role. We are therefore on to just and equitable. Now, if I can just briefly, and at the risk of telling your lordships what you are already well aware of.
Can I be sure I understood how that fits into the grounds of appeal? Ground one is that the judge was wrong to find that he should have appreciated the speed, and we're past that
Yes.
point. Ground two is, well, even if there was fault, there wasn't sufficient blameworthiness. And is your submission that there's no middle ground? Either you're not at fault, or if you are at fault, you're blameworthy?
No, my submission is that fault means failure to take reasonable care. Now, where one balances who has done what and how appalling it is, egregious, whatever it is, and whether it is momentary inadvertence in a case like this, comes into play in the just and equitable.
Yes, we need to be careful with the
my
phrase momentary inadvertence, because I think you've accepted that some cases of momentary inadvertence mean you don't cross the line into fault at all.
Indeed.
But once you've crossed the line into fault, then and there's a causation, which is just a question of fact. I mean, that's not a question of assessment. It's just a question of fact. If you hadn't done, in this case, stepped off the curb, you wouldn't have been hit. Once you've got to that stage, then it is just and equitable.
Yes.
I think you were cavilling, my lord, putting to you that fault and blameworthiness were in your submissions the same thing. But I think they are, aren't they? There's obviously degree of blameworthiness, just as there's degree of fault, and that feeds into the just and equitable exercise.
Exactly, yes.
But for myself, I haven't detected any real difference between the concept of blameworthiness and the concept of fault. By all means, say if you think there is.
No, I suspect your lordship is right, But there still needs to be a balancing act by the judge at the conclusion.
Oh, of course.
After 1 and 2.
Of course.
To step back and say, is it just and equitable?
Of course. And that balancing act involves assessing the degree of blameworthiness, square brackets, i.e. the degree of fault, which he's already found, compared with the degree of blameworthiness, and also in a case where it's important, the degree of causative potency.
Yes.
Just to pick up on that, your questions 1 and 2 are yes/no questions. I mean, either you are at fault or you're not.
Yes.
Either it did contribute causatively to the injury or it didn't.
Yes.
But question 3 is obviously not a yes/no question. Question 3 is the just and equitable is a question of what's the degree.
Yes.
And for questions 1 and 2, it doesn't matter whether you're only just at fault or whether you're massively at fault.
No.
You're at fault if you are.
And hence, on the judge's finding, he looks at the claimant's conduct and he's not at that point comparing it with the defendant's conduct. He's looking at it in the light of what the claimant as a 13-year-old ought to have appreciated.
So he's measuring it against the standard of a reasonable 13-year-old in those fact-specific circumstances. And either it crosses the line or it doesn't.
Yes.
But if we go back to Davis and Swan, top of page 34.
Yes.
What the court appears to me at be saying is you take the statutory words, which is what is the claimant's share in responsibility for the damage, and in doing that you look at 2 things: 1, causative potency, and 2, the word that's used is blameworthiness. But that's not so much moral culpability; that's the degree of tortious fault.
Responsibility.
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 No, responsibility.
This is a gloss on responsibility.
Responsibility has
yes.
two components.
That's what I was meaning. I was meaning this is, in effect, a definition of responsibility in this context.
It's a gloss on.
Yes, a gloss on.
Well, presumably, take a concrete example. If a driver is driving at 25 miles an hour in a 20-mile-an-hour zone and is unfortunate enough to hit somebody, he's at fault, but his blameworthiness is not the same as a driver driving at 50 miles an hour in a 20-mile-an-hour zone.
No.
Or if he's doing it because he was working late all night and wasn't properly attentive, and as opposed to if he'd had 5 pints of beer. Those are questions of degree of fault.
Yes.
I would have thought.
Yes.
But if you want to draw the blameworthiness, mate, that's fine as well.
I suspect we've reached the same conclusion, perhaps by an inelegant route on my part and with some ambiguity, that this is a 3-stage process.
I still think it's a 2-stage process, but I'm not going to. I think we all understand one another.
Can I take your lordships then to, briefly, if I may, to Jackson Murray, which is the first authority of the bundle, the authorities bundle. It's a Supreme Court decision in which Lord Reid gave the judgment, the leading judgment, for the majority. The facts perhaps don't need to trouble us particularly. It was a 13-year-old who was found contributory negligence to a very high degree at first instance, 90%. That was then reduced to 70% and to 50% by the lordships.
Well, she ran across a busy A road without looking.
Yeah. Yeah. So it's not comparable. And as I've said before, these cases are fact specific. But if I can take you briefly to paragraph 28. Lord Reid says there it follows the apportionment of responsibility, and this is in the context of the 1945 Act, is inevitably a somewhat rough and ready exercise, and a variety of possible answers can legitimately be given. Over the page, he uses the phrase within the limits of reasonable disagreement, and elsewhere, your lordships note paragraph 35. It's only a difference of view as to the apportionment of responsibility which exceeds the ambit of reasonable disagreement that warrants the conclusion, etc. And outside the range of reasonable determinations is a phrase that appears in paragraph 38. So the error of law that this judge needs to have made for this appeal to succeed on just and equitable is that it was not open to him to find that a reduction of 10% was just and equitable in a case such as this, on the facts as he found them. And in my submission, that is not an error or a finding with which this court ought, with all due respect, to interfere. The starting point is that he has found fault. He has found it in a fairly fundamental degree, stepping off the pavement when he shouldn't have done so, and, as a subsidiary, not looking once he's in the road. So the starting point is that he has found fault, notwithstanding age, and that it was contributory. The next point is that the phrase just and equitable in the 1945 Act and the share of responsibility, etc., are matters that permit judicial discretion and judgment as one would expect of a first instance judge. And this judge has borne in mind all the factors that my learned friend praised in aid, the various facts as to the speed, that it was appalling driving, etc., that it was a modest distance that the claimant had to travel. This judge took all those into account, so there is none that he fails to take into account. The complaint is not with his reasoning process, it's with his conclusion. The next point is that there is, as I understand it, no authority to suggest that a 10% finding against an adult or a child is by definition impermissible under the Act. The nearest one gets to it is the case of Casson, which I do apologise, I added to the list late in the day, but it should be in your Lordship's bundle of the final authority. It's a short judgment of this court.
I'm not sure I've got it in hard copy. Would it have come on an email?
I believe it came as email. I do have a hard copy if your Lordship needs one, because I anticipated that this might be a problem. Would you pass it up?
If I could have one, yes, please.
Thank you. This is an industrial accident.
Thank
you. And it's an adult claimant. Now, for my purposes, I'd merely refer this court to paragraph 1, where the court say it's a short form judgment and raises no issue of law on matters of general application and significance, which is in support of the submission that I'm making. Paragraph 4, the finding by the judge at first instance was that the claimant was negligent himself and damages were reduced by 10%, so 10% in an adult case. And the appeal is allowed because at paragraph 15, as a question of fact, the finding of fault was not justifiable.
So you're really just saying, Casson isn't such. Casson doesn't say you can't find 10%. Exactly. It just says there wasn't justification.
It was regarded as a question of fact, not one of principle.
Well, that slightly depends on what points were taken in the appeal. And all you can really say is the point doesn't appear to have been run.
Exactly. Had it been run, one might have expected the Court of Appeal to address it, but I take your Lordship's point.
Well, quite. I mean, this doesn't really. I'm glad to have seen it, but it doesn't really advance the argument.
No. I didn't want to be criticised for not referring something to the court that might be irrelevant. Sorry, just give me 1 moment. The other fact that one needs to bear in mind where there is a finding of 10% against a claimant is that had it been an adult, it would have been a higher finding. And if one poses the question, well, suppose that this judge had found that the claimant who was 45 was guilty of contributory negligence to the extent of 20%, we wouldn't be here. That would be a finding that nobody would question as being a just and equitable finding open to the judge in the facts as he found. Now, he has therefore applied the reduction, or a reduction that he ought to have done. Some judges might only have applied a reduction of 5% from the 20%, but he's halved it. That's not how he explains it, but in effect, that's what he has done. So he has compared the fault that he might have found against an adult in a situation like this and reduced it accordingly because the claimant is 13.
Does he say that
He doesn't say that. That's my deduction.
But it's clear he took into account the fact that in finding what was just and equitable, he took into account the claimant's age, so it's implicit. At least I think that's right, isn't it?
I would submit so, yes.
Well, he didn't say it, but I thought he did say it.
Well, I'm looking at 97 to 100, and I don't see, unless I missed it, the reference to his age. He sets out at 98 all the factors which make the causative potency extremely high to weigh heavily against the first defendant. And then 99 deals with the suggestive brackets. And in 100 he says it can't be wholly ignored, but he puts it right at the bottom of a suggestive bracket.
Yes.
I'm not sure he really says it might have been different if he was an adult or I take into account his age. He's taken account of the age in reaching the finding of fault in the first place.
He has, yes.
Once you've got to that stage, he thinks you ought to make some deduction, but
Yes.
puts it as low as he thinks he
I was not suggesting that he had expressed himself in that way.
I think I suggested he had, but now I look at it
My
again.
submission was that had this been a case of a 48-year-old or 45-year-old or whatever having done this and faced a finding of 20% contributory negligence, no one would have batted an eyelid, and this would not have been given permission.
Well, I think I can think of some people who would have batted an eyelid, but your better submission may be it would have been a finding that should have been secure on appeal.
Absolutely. Much more elegantly put. The other crucial factor, of course, is age here. In Ellis and Kelly, the child was 8 years. So in Ellis and Kelly, the child was 8 years, 8 months. And no finding of contrib was made against that child by Mrs. Justice Year. In Alabadi, the child was 9 years, 2 months. No finding of contrib was made by Judge Bird. And in AB and Maine, Judge Stephen Davis made a finding of 20% against an 8-year-old, 10-month-old claimant.
All this banding about in different cases is really irrelevant, isn't it?
It is, because it's fact specific.
All you're saying is he was 13, not 8.
Exactly.
See that?
And the judge took that into account.
13 years, 8 months.
Yeah.
If one's being really picky.
Can I ask you this? He says in 100, I do not think his culpable misjudgment can be wholly ignored. Would it have been open in your submission to a judge on these facts to say, I know I found fault, I know he shouldn't have stepped off the curb, the defendant's conduct was so appalling that I think I am going to make him pay for 100% of it?
My submission is not. My submission is, having found the fault as he did and the causative effect, the responsibility, then in that circumstance, in my submission, the finding of contributory negligence was effectively inevitable.
So he's right to say, I really ought to make some deduction.
That's my submission, yeah.
Yes. Is there any authority?
But I don't, no, there isn't.
Yeah.
But in fact, I don't need to go as far as that.
No, obviously you don't.
Just not fallen into an error. But
I understand that your submission is we can only disturb it if he's fallen outside the range of reasonable disagreement.
yes,
And there's nothing wrong with saying, I'm going to make a very small
absolutely,
deduction of 10%. There wouldn't have been anything wrong in saying I'll make a deduction of 20%.
absolutely.
But on this question of whether 0% is possible, there are certainly analogous, there may not be perfect analogies, but analogous areas where courts have to do exercises of this kind, I can think of in the field of employment law,
Yes.
where the court is empowered to make a finding of just of some kind of deduction and compensation on the basis of that it would be just and equitable to do so.
Yes.
I may be thinking the other way around. You can have a case where someone has contributed to their own dismissal to the extent of 100%, even though the employer
Yes.
has acted unfairly. And it's just and equitable to make a deduction of 100%. That's perhaps not an analogy, actually, as I talk it through.
No.
Are there other fields? What about contribution between tortfeasors? The language is very similar.
In the 78 Act.
Yes. I'm just slightly
Yes, I think
surprised
the phrase
that the
just
question
now-
has never been faced up to. Speaking for myself, I would have thought that in an appropriately extreme case, it would be open to a judge to say it is just and equitable that there should be no deduction. But that's not your submission.
No.
Just picking up on that, and speaking entirely for myself, for example, the fact that he was fleeing from the police is not his tort. So, for my instinctive approach is to look at the tortious conduct and the responsibility that each bears, and his tortious conduct is at driving at 45 miles an hour and not keeping a proper lookout.
Yes.
And although just and equitable often has a moral connotation, what the Act enjoins one to do is to look at the responsibility, the relative responsibility of a tortfeasor and a claimant who
Yes.
has also been found to have acted without reason.
Or the damage.
For the damage.
Therefore, one focuses upon the event itself.
Yes, so just taking the facts of this case, for myself, I don't think I would take into account the fact that he was fleeing from the police or that he'd been dealing drugs or fake Apple products or whatever.
And I think, to be fair to the judge, he doesn't do that.
No.
In 98, where he sets out all the factors to put on the defendant's side of the scale, it's all about how badly he's driving, how fast. He does say his motivation, the desire to avoid arrest.
And I don't think Mr. Rose is actually saying we should take into account that he was dealing fake Apple products or that he was escaping the police. But I just thought I ought to
No,
raise
clearly.
that.
Well, I think these are quite deep waters, which are not directly raised by any of the issues. I'm not entirely sure my instinct is the same as my lord's. I agree that you can't go
Well,
back to dealing with fake Apple products, say, but I would have thought that the fact that his motivation was the desire to avoid arrest is something that the judge ought to have taken into account, but he did. So
yes, one could see that would
doesn't
explain
help.
speed and inattention, and therefore it may bear upon the event itself.
my example of the person who's driving fast because he has drunk a lot being
Yes.
more blameworthy than someone who is driving fast because they are late for work or something.
Yes. And in contributory negligence, there is authority that if the pedestrian is drunk, you don't, and commits an error of judgment, you don't penalise that claimant for the fact that his inattention, his fault, has been brought about by.
Oh, is
his
that
drunk.
right? Well, what's sauce for the goose ought to be sauce for the gander then.
No, because the pedestrian doesn't.
He doesn't owe a duty of care.
No, but one's talking about the blameworthy. Of course, that's right. But if one's thinking of blameworthiness, you might say that the pedestrian whose carelessness is due to being drunk rather than to momentary inattention is more responsible, to use the words of the statute, than the momentary inattention one.
I rather suspect that we don't need to resolve.
Well, I don't think we do, but the more we explore this, the more I think in another case it might make a difference.
Yes.
But it doesn't here on the grounds of appeal, and indeed on the way the judge chose to reason it.
Yes. It's possibly a moral philosophy problem as much as anything. But my submission is that it doesn't make any difference in this case because he has taken into account some part of the background in describing
Well, the real thrust of paragraph 98 is that the first defendant's driving was just appalling. And as I say, everybody has always accepted that.
There was almost a competition amongst counsel to come up with the most damning phrase for the first defendant's driving. But the judge was aware of that.
And that goes into the mix and is why he produces a 90-10 result. There's no sense in which the two are morally or legally equivalent.
No, and he didn't pretend they were.
No. But your submission is whether or not he could have set it at 0, setting it at 10 does not involve any error.
Absolutely.
With which we can interfere. That's your submission.
Exactly. Yes.
Well, all you can say, isn't it? But
well, I've said it in rather a long-winded way, but
no. Well, we've taken you down one or two side alleys. So, is there anything else?
Have any other questions of me? Those are my submissions.
No.
Thank you, Lord.
Yes, Mr. Rose.
There's not a lot to be
No.
with respect to Mr. Horlock. That's not a criticism. Brevity is always to be admired. I mean,
But on ground 3, it really is simply a matter of whether, assuming that another outcome was possible, we can go so far as to say that the outcome the judge chose was outside the range of reasonable disagreement.
That's
the matter
precisely
for
the
us.
point on ground 3. I mean, just picking up on the point that was being exchanged between bench and bar about, well, what's the relevance of the fact that he was fleeing the police and driving to avoid being arrested, etc. Is it neutral, or and is the focus simply on the fact that he drove at 45 miles an hour and didn't keep a proper lookout? I mean, if you take the example of somebody on the motorway in an articulated lorry who is texting on their phone and drives into a vehicle that's stopped in stationary traffic on the motorway, one would think that more culpable conduct than a lorry driver who is momentarily distracted because something happens on the other side of the motorway, takes his eyes off the road momentarily and crashes into the back. And one would expect, for example, in the sentencing of such an individual, that to be reflected, a degree of culpability. And in this case, it is a characterization of the defendant's conduct is that he had a wanton disregard for other road users because he was saying his own skin.
I do absolutely see that, Mr. Rose, but it's not part of your submission, and it can't be, that the judge didn't take that into account, because he says he did. Arguably, if my lord is right, he was a bit too favourable to you in doing so, but the question doesn't arise for that reason. Your case is that he should have paid even more attention to it and come out at naught.
Yes, well, what I was doing, I was picking up the point that exchanged.
I'm not criticising you, but I'm just
giving you the reason why I think it is relevant.
Yeah.
You're saying, well, if it is relevant, he's found in your favour on it anyway. So what are you arguing about? To which I suppose my response would be, it's all the more startling, given these were the circumstances, that he made the finding he did. Well, I want to think if I say anything else, I'll be repeating what I said to your lordships earlier.
Well, I repeat what I say. Your submissions have been both succinct and cogent. We will be reserving our decision, I hope not for very long, that means, as I needn't tell you, but it's conventional to do so, that a draft judgment will be circulated in due course to council to enable them to agree the terms of any consequential order, or if they can't agree, to provide short written submissions on the basis of which we'll resolve any difference. Also pleased to draw our attention to any typographical or other minor factual errors, but we would wish at the time of hand down, which parties needn't attend, to deal with all consequential matters. Thank you and those behind you for both your submissions and for well presented bundles and disc.
Thank you very much indeed, Madam.
All right.